So I think, Ruchi, the next question is to you. And the next really crucial aspect of having any kind of a technology collaboration is that when there is technology being shared with an Indian party, it's a typical commercial provision to have indemnities provided, right? So your Indian party will provide indemnities in favor of the licensor. But I think there are some nuances
Yeah.
in India because of the currency control regulations, right? So do you want to touch on that maybe?
Yes, sure. I mean, in addition to intellectual property laws and the labor laws, I think one should definitely be mindful of the exchange control regulation in a cross-border context. As I mentioned, currently there are no restrictions for transfer of technology into India. But like Shreya mentioned, your right to enforce an indemnification and get your claims for indemnification, there can be challenges. Let me explain this. For example, in a pure strategic alliance or in a JV or an MNA, in a document, if you've agreed for an indemnification with an Indian party, and the indemnification gets invoked, in such a situation, there may be an approval that may be required from the Reserve Bank of India, and this can pose a challenge. Of course, in situations where there is a court order which allows payment of monies to the foreign party towards indemnification, such an approval may not necessarily be required. So you should be mindful of documenting an indemnification, but the challenge which exists on exchange control front.
I see. So very interesting. So that's another example of a provision or a protection that you may have contractually that may not in practice be available to you because of challenges with
Yes,
enforcement in India.
yes.
So I think,
Yeah, I'm taking the
yeah.
Sorry, I'm taking the point on enforcement. I think it is important to cover the unique law legislation that we have in India, which is the stamp duty legislation. Apart from intellectual property, labor laws, exchange control, in order to have a valid, binding, and enforceable contract, one needs to be aware of this unique legislation. As listeners may be aware, in India, if you execute a document in order to make it enforceable and it to be regarded as admissible as evidence in the court of law, it needs to be stamped or franked with the authorities. This means a payment of certain revenue, payment of certain fees to the revenue authorities. And if the document is not properly stamped or adequately stamped as per the state law, and as per the stamp duty mentioned or prescribed for the document may not be admissible as evidence. And therefore, one needs to be aware of the unique legislation in India.
I see. So, Josefa, would you say there's a high degree of awareness about stamp duty obligations, or do you see a lot of non-compliance amongst companies?
So usually the mindset from a cross-border perspective, Shreya, when there is a foreign counterpart, the mindset, if even if there is awareness, the awareness is not to that extent that it is a legal requirement. Because if we're sitting outside India and executing documents,
Right.
we usually tend to believe that the law would not apply to us.
Right.
Forgetting that the other party is an Indian counterpart, and as Ruchi just explained, and she played it, she gave a very valid example that tomorrow, if you need to enforce anything against the Indian counterpart, that's where you'll be caught napping if it's not adequately stamped or not duly stamped.